Okay, in today's episode of Intellectual Property, the final episode on copyright law, we're going to be talking about secondary liability or liability for copyright infringement actually caused by a third party and when somebody can be liable or at least potentially liable for copyright infringement committed by someone else. So the first case that you saw in the casebook was Fonavisa v. Cherry Auction. And essentially what happened in the case is Cherry Auction is a flea market, basically, based in Fresno, California, with a very wide range of different vendors offering materials for sale. Among other things, there were many vendors who were selling CDs, and specifically, they were selling bootleg CDs. In other words, they were making copies of CDs and selling them without getting permission from the copyright owner. Right, so these were counterfeit or bootleg CDs that they were selling, and the music publishers essentially called the cops on the vendors several times and told them to stop selling bootleg illegal CDs. And actually, that is at least potentially criminal under the Copyright Act to sell counterfeit goods. And they didn't stop. And more importantly, Cherry Auction didn't stop them. In other words, Cherry Auction didn't go after the vendors itself. And as a consequence, the music publishers, the copyright owners, went after Cherry Auction as well as the vendors who are actually engaging in selling the bootleg CDs. So I wanted to play for you a little video just to give you a sense of what Cherry Avenue Auction is actually like.
You found the Cherry Avenue Auction website. That is awesome. I'm Kopi Soteropoulos, and I'm going to give you a tour of the largest open-air market in Central California. It's been around since the 30s. It's a valley tradition, generation after generation after generation. They host auto swaps. They have the greatest bargains and deals for everyone in the entire family. And I'm going to give you a bird's-eye view. Are you ready? Here we go. Take it away!
So you're looking for produce, you can't go anywhere else except here. Look at this. Pick 'em up. Cucumbers, what a great value. Cactus, there, bananas. Oh, look at these little cute baby bananas. Maybe we find the soup for them. Thai chili peppers, hot.
Sweet and juicy pineapples. Juicy red pomegranates. Folks, where do you start? We have rows and rows of produce. We have fresh fruit. Look at this. We have cactus. Beautiful flowers. And we have spices. Guess what? Some of them are really hot. And we have stuff that's in season. And guess what? In the right season. Right here at Cherry Avenue Auction. From all that shopping, I really worked up an appetite. They have authentic Mexican food. They have pizzas. They have hot dogs. They have hamburgers. They have Chinese food. I mean, where do you start?
Wait, I got a great idea.
Why don't you try it all? I am.
If you're thirsty for a beer, you can enjoy one in Central Plaza in the beer garden. Look at the bling here. We've got all kinds of jewelry. You've got the elephant-shaped necklaces. You have crosses. You have beautiful. Look at this cross right here. That is gorgeous. It's gorgeous. But one of the things that caught my eye was this beautiful heart. Now, what young lady would want to have a heart like that?
What a great selection of furniture. Bedroom sets for adults, bedroom sets for your kids' rooms, the dressers, the drawers, the bunk beds, dinette sets. Look at these. That is gorgeous. And of course, these wonderful couches.
They look great in your house. I kind of like this one.
I had a great day of shopping at Cherry Avenue Auction. I got tomatoes, bananas, zucchini, garlics, and toys. Don't worry, I didn't take it all. I left some for you. The owners, Neil and Mitch Burson, would personally like to thank each and every one of you for visiting our website. And all of us here want to invite you to come out for a great day of shopping at Cherry Avenue Auction year-round. And this is Kopi wishing all of you a great day.
Okay, well, so as Kofi observed in that memorable video, Cherry Avenue Auction offers all manner of different kinds of products, including CDs. Now, presumably some of the CDs that were sold by the various vendors at Cherry Avenue Auction were legitimate and licensed or produced by the copyright owners, and presumably some were used and therefore permissible to be resold under the first sale doctrine. But a lot of them weren't. Right? A lot of the vendors were selling bootleg CDs, presumably ones they probably got from someone else and were then retailing, and the music publishers wanted them to stop, right? This is back in the day when people still bought CDs. As far as I know, that doesn't really happen anymore. And they went after, ultimately, Cherry Avenue Auction, for permitting the vendors to sell the CDs at the auction in the first place. But the problem was that Cherry Avenue Auction wasn't actually selling the CDs itself. The vendors were, right? So there was no direct infringement of the distribution right by Cherry Avenue Auction. It was only an indirect infringement insofar as Cherry Avenue Auction was permitting the vendors to make the sales. And so the court looked to two different theories by which Cherry Avenue Auction could be liable for copyright infringement based on the distribution by the vendors of the bootleg CDs, right? So the first theory was vicarious liability. The second theory was contributory infringement. And they're really similar. They effectively end up at the same place, but they have meaningfully different and importantly different elements that reflect different ways of thinking about why we might find secondary liability based on somebody else's infringement. So in the case of vicarious liability, in a sense, it's like a version of a principal agent argument, right? It's like a version of respondeat superior, right? The idea with vicarious liability is that the defendant has the ability to control what the actual primary infringer is doing and derives benefits from those activities. So what's the theory for liability for Cherry Avenue Auction under vicarious liability? Well, Cherry Avenue Auction could tell the vendors, you're not allowed to do that. You're not allowed to sell bootleg CDs, right? They are in a position to prevent the vendors from engaging in the relevant infringing activity. And right, Cherry Avenue Auction also benefits indirectly, but still benefits from that infringing activity. Specifically, right, Cherry Avenue Auction gets more rental fees because of the additional vendors who want to come sell bootleg CDs. And to the extent that the bootleg CDs are attractive to Cherry Avenue Auction's customers, it's also attracting more people who are paying tickets, buying tickets to come into the auction, and also buying food and so on from the various vending, the various food vending operators that Kofi so memorably introduced us to, right? So not only could Cherry Avenue Auction stop the infringement and chose not to, but also it derives an indirect benefit from the infringement, making it, or rather opening it up to vicarious liability. In addition, the court found that Cherry Avenue Auction was also a contributory infringer insofar as it offered a venue for the vendors to be selling the bootleg CDs, right? It made it easier for them to do so, and it did so knowingly because that was beneficial to itself, right? So slightly different in terms of sort of the conceptualization of why secondary liability might exist, but still arriving at the same place, saying that the copyright owners aren't limited to bringing an action against the primary infringers. They can also bring an action against the secondary infringer, and really they want to be able to do that because going after the primary infringer isn't going to really get them what they want, right? What they're really concerned about is the fact that Cherry Avenue Auction is offering a venue that facilitates copyright infringement of the relevant kind, right? And they want to stop the venue from existing, not just the individual vendors. Okay. So secondary infringement also came up in the context of the Sony case that we talked about in our last class, right? Essentially, the movie studios said, look, Sony, you're a secondary infringer because you're producing a machine for infringement, right? After all, what is a VCR but a machine that allows people to make copies of audiovisual works, right? Anytime they make a copy of a copyrighted work, that's an unpermitted, right? That's an unlicensed reproduction. That's infringement, right? So this is a machine for infringing copyright. And Sony ought to be liable for making that machine because A, right? It, like, at least in theory, has the ability to control the primary infringers, at least insofar as it made the machine in the first place. And it benefits from the infringement because that's why people want to buy the machine in the first place. Moreover, by producing the machine, Sony makes infringement possible, right? So there's their secondary liability theory, right? And the court says, no, look, this is a technology that has many different uses. Some of the uses are infringing, but a lot of the uses aren't. And as long as the machine has substantial non-infringing uses, we're not going to find that the technology is impermissible and creating secondary liability because it can be used for non-infringing things as well, right? And if it can be used for non-infringing things as well as infringing things, we are going to permit the production of the technology in question. We don't want to deprive consumers of valuable technology just because it could be used for infringement. We're only going to limit technologies that can only be used for infringement. Well, fast forward to 2005 and the Grokster case. I don't know how many of you are still familiar with file sharing sites like Napster, Grokster, etc. Right? Essentially, what Napster did was hold music on centrally located servers. That was pretty clearly infringing because they knew what the material that they were holding was, and they knew that it was copyright infringing. Grokster tried to get around that in a way kind of reminiscent perhaps of the Aereo case we talked about earlier. What did they do? Well, they set up a system where they just connected users to each other. It was a peer-to-peer network. In other words, Grokster just said, look, we're a clearinghouse for people who want to exchange files. None of our business what files you're exchanging. We're just going to connect people who have things that they want to share with other people. We don't know what you're sharing. We don't really want to know what you're sharing, but go ahead and share away, do your thing, right? That'll be great. And everyone will have access to different kinds of material. In other words, they didn't do any copying themselves. All they did was facilitate their users, third parties, to be sharing files, computer files amongst themselves. Well, what were those users sharing? Primarily copyrighted music and movies, right? As well as computer games, right? So the overwhelming majority of content that was being shared on Grokster was copyright infringing content. In other words, people were using it as a clearinghouse for sharing copyrighted material with each other. And Grokster benefited by selling advertisement, right? I mean, the more volume on Grokster's website, the more money Grokster made because what it did was sell ad space, right? Well, the movie studios, among others, brought in a copyright infringement action against Grokster, alleging secondary infringement. And Grokster said, hey, we just are providing a technology that enables people to share files. Sure, they can share copyrighted files, but they can share uncopyrighted files too. I mean, who knows? They can share anything they want to, right? Some people are sharing copyrighted things. Some people are sharing uncopyrighted things. None of our business, right? We're just providing a technology. People can use it however they want to. And as the court said in Sony, if the technology has both infringing and non-infringing uses, well, the non-infringing uses carry the day, right? The non-infringing uses mean we don't have to worry about an infringement action. And the court said, wait, not so fast, right? Not so fast. This is a technology that's designed to be used for infringement. It effectively looked at the actual business model of Grokster and said, look, it's true that this technology can be used for lots of different things, but you are inducing people to use it for infringement, right? Why did you call yourself Grokster? Because you wanted people to associate you with Napster. And what was Napster all about? Napster was all about copyright infringement, right? That was the whole purpose, right? You are selling your product to consumers as a means of facilitating copyright infringement. And the fact that it could be used for non-infringing purposes is not enough, because you're telling people to use it for infringement. And in fact, that's what they're using it for. And in fact, you want them to use it for that, because that's what's making you money. The overwhelming majority of your users are copyright infringers. And the more users you have, the more advertising revenue you generate. Ergo, according to the Supreme Court, you are liable for copyright infringement because you're encouraging copyright infringement by your users, even though you're not doing it yourself, and even though your technology could be used for lots of different purposes. Ironically, of course, file sharing technology has become a really important tool that people do, in fact, today use for all manner of different purposes. So one more interesting example of a circumstance where something that, looked like it was going to be market disruptive and wasn't obvious what the productive use was going to be, turned out to be a real boon and a real benefit to the industry. And if anything else, right, Grokster really alerted music and movie publishers to the reality that what people want is easy access, right? What they want is to be able to get the content that they want to consume as quickly, as seamlessly, and as painlessly as possible. And today, right, the market is for streaming, right? And streaming is kind of a version of what file sharing sites like Grokster and Napster pioneered. So anyway, let's leave it there, and I'll see you in class on Wednesday.